Hi, Bill Henshaw here again. This is part two of my introduction to my new YouTube channel, You Win in Court, which is an extension of Constitutional Crisis Channel. And here we're going to try to simplify things and make it easier for you to understand what's going on and how to get into court and beat the bastards. Now, we started out with the Bill of Particulars, and that's a great start. You take control of the case right away, and they never get it back. That's the best document I think I have in my constitutional defense documents. Part two is about the 14th Amendment, and we understand what this one does and what they're doing in there and how you can get around it. This is where you start to beat them. And I'm going to read a little something to you. I hope it'll simplify what's going on here with the amendment and why it doesn't exist. The non-existent 14th War Amendment, and that's what I call it, is the key issue to understanding all of the unopposed constitutional issues which I present and discuss, albeit briefly, in 5 major constitutional issues, any one of which is sufficient to have defeated the quote-unquote amendment and would defeat it today. The skeptics among us might say that 150 years later is a little too late, to which I respond with the words of the 9 old farts, aka the U.S. Supreme Court, from their decision in Ashwander v. Tennessee Valley Authority, 297 U.S. 288, page 345. The court will not anticipate a question of constitutional law in the advance of the necessity of deciding it. You don't ask, we won't answer. And the 9 old farts know that no member of the Supreme Court bar in his right mind will ask, and that 99% of the American people were not taught any of the right questions to ask in the mandatory public quote-unquote education system. Why should we care, you ask? Because the entirety of the Constitution and fabric of the federated Republican form of government ordained and established by we the people depends on defeating this amendment, and the failure to act will doom you and your posterity to a life of slavery. Congress submitted the 13th Amendment to the exact same legislatures than the states then lately in rebellion for ratification, and this amendment was ratified. This was a stipulation by Congress to the legitimacy of these state legislatures as created by the Reconstruction Plan of Lincoln and Andrew Johnson, who, as commanders-in-chief of the armed forces, had the power to quote-unquote rehabilitate these states, which Congress did not have and does not have. And to the extent applicable, these legislatures had the power to ratify the 13th Amendment and reject the 14th War Amendment, which all of them did in sufficient numbers to defeat the amendment today, let alone in 1865. Point 2. Without any representatives and senators from the southern states who were summarily and unlawfully denied their seats in Congress, there was no quorum to even propose at least the 14th War Amendment. In other words, the southern states had no way to participate in any Congress from at least 1861 until 1879. Where can we find the consent of the governed in such a situation? Point 3. With the rejection of the proposed quote-unquote amendment, Congress quote-unquote enacted perhaps the most unconstitutional law ever, the Reconstruction Act of 1867, dividing the southern states into 5 military regions, and compelling quote-unquote ratification of the 14th quote-unquote amendment as a condition for readmission into this union, which they were never out of, as contemporaneously ruled by the 9 old farts in Texas v. White, 74 U.S. 700. Indeed, the 9 old farts also contemporaneously ruled the Reconstruction Act unconstitutional in Ex parte McArdle, 74 U.S. 506, but were not allowed to announce their decision and have been conspicuously silent ever since. Is the gentleman's agreement quote-unquote in effect here? Point 4. It's a matter of record that the 36th Congress declared at the outset of the war in 1861 that this was not a war of conquest, but a rebellion to be put down and disunion, quote unquote, to be made whole. Point 5. That leaders of succeeding Congresses during the war between the states, such as legal, quote unquote, luminaries like old Dad Stevens, George Boutwell, and Charles Sumner, took the position without any apparent support that it was a war of conquest and that the states lately in rebellion were not part of the United States. This was exactly opposite the position taken by Abraham Lincoln and Andrew Johnson, whose policies pursuant to Reconstruction were not only consistent with the Constitution, but they, as commanders-in-chief of the armed forces, had the constitutionally mandated power to handle all matters pursuant to a historically unprecedented situation which confronted the United States after the surrender of General Robert E. Lee. Congress can declare war, but has no power to end it as such. And aside, with such a benevolent humanitarian view of Reconstruction, it is ludicrous to believe that John Wilkes Booth acted at the behest of any interest of the Southern states in assassinating Lincoln. While a subject for another video, a much better place to look for villains is in the immediate vicinity of 120 Broadway, New York, New York, home of the Wall Street banksters. Point 6. Given that for all apparent intents and purposes, the non-existent 14th War, quote-unquote, amendment has been held to extend the sovereign body politic of the nation and republic. Parenthetically, this is the only United States citizenship, quote-unquote, now recognized, and or that the cleverly concealed intent of the amendment of the secret Joint Committee of 15 on Reconstruction was to make citizens out of artificial corporate entities, C.E.G. the cogent and compelling dissent of Justice Hugo Black in Connecticut Insurance v. Johnson, 303 U.S. 77, page 87, available on request by email to me at uwinandcourt@gmail.com, which said in relevant part here, neither the history nor the language of the 14th Amendment justifies the belief that corporations are included within its protection. Certainly, when the 14th Amendment was submitted for approval, the people were not told that the states of the South were to be denied their normal relationship with the federal government unless they ratified an amendment granting new and revolutionary rights to corporations. This court, when the slaughterhouse cases were decided in 1873, had apparently discovered no such purpose. The records of the time can be searched in vain for evidence that this amendment was adopted for the benefit of corporations. In this case, the 14th War Amendment, quote-unquote, would have had to have been ratified by people in conventions of the states pursuant to Article 5 of the Constitution, not by their agents in the legislatures. In addition, is the case against the non-existent 14th quote-unquote War Amendment as stated in the Congressional Globe of June 1967, also available on request via email at uwinandcourt@gmail.com. While not as thorough in scope as presented in my documents, you'll clearly see I am hardly the only one opposing the 14th War Amendment, and that all of us should be up in arms. Point 7. The citizenship available from Section 1 of this quote-unquote amendment applies only to those, quote-unquote, subject to the jurisdiction of the United States, which lawful de jure jus sanguinis state citizens are not. And none of the victims reads or understands Section 4 of the quote-unquote amendment, which states in relevant part that the validity of the public debt of the United States authorized by law shall not be questioned. Indeed, the publicly stated and beneficent intent of the non-existent 14th quote-unquote War Amendment was to make citizens out of the freedmen who had been slaves in the southern states and who did not have any citizenship at any prior time in American history. And think about this, the ratification quote-unquote of the non-existent 14th War Amendment reversed the relationship of we the people to the Constitution and government we ordained and established to preserve the blessings of liberty to ourselves and our posterity, from principal and agent to master and slave. And I'll have a lot more to say about this New York bankster treasonous travesty in future videos. Thank you.